Welcome back to Opinions My Own. I'm Paul Caulfield, and with Zila Acosta-Grimes, we are bringing to you various aspects of money laundering, technology, and the law. And in this episode, Zila had a really nice opportunity to speak with a partner at Sidley Austin, Lilya Tessler. Just to level set, a few weeks ago, we talked to Amanda Wick, who was also a lawyer who had moved over to the FinTech space. Lilya actually offers a tried and true lawyer's perspective on what she's doing within the space. But you had the time with her. So Zila, why don't you give us a little bit of a preview?
Sure. So Lily, just for everyone to understand, when I talk about working at a law firm, we actually worked together many years ago, and Lily is now a partner, as Paul mentioned, at Sidley. She's actually the head of Sidley's FinTech and blockchain group. Her clients are a lot of the companies we've been talking about, and a lot of the companies the folks we've been speaking to in this podcast actually work at. So the FinTechs and the technology companies and the banks, all of these are clients of Lily's, and she helps them kind of navigate this very, very difficult terrain when it comes to regulation, new regulation, lack of regulation. She's there for her clients and gives them kind of that solid legal advice. It's an interesting industry. There aren't many women in this industry. Lily's kind of young and innovative and has built this group out at Sidley. So we kind of talk about all of those things in our conversation. So I'm excited for you all to hear it. Let's give it a listen. Hello, everyone. Welcome back to Opinions My Own, our AML podcast. And with me today is Lilya Tessler. So as you all know, I'm one of your co-hosts, Zila Acosta-Grimes, and Lily and I actually used to work together. Lily is a partner and head of Sidley's FinTech and blockchain group. She has had a varied career and is really an expert in her field. And Lily, like myself, is a lawyer. So I actually think we're going to have a great conversation today about the types of clients she advises. As you know, previous podcasts have we've talked to people who I think would be clients of Lily's. Who knows if they are, we won't ask her. And also just some of the issues that have come up in this space. So Lily, maybe you could kick us off and just tell us a bit about yourself and kind of how you got into this line of work.
Great, thank you, Zila, and thank you for having me here today. So by background, I come from a traditional financial services regulatory background, worked on securities, broker-dealer, regulatory issues, actually as in-house counsel in many financial institutions in New York, but also really had a keen interest in some of the companies that I worked for that were developing emerging technologies, primarily for regulated financial institutions. Algorithmic trading, alternative trading systems were coming into being, and I was tasked with some of those roles and implementing the existing regulation, how it applies to digitizing and creating electronic trading tools, which was kind of the FinTech of that time. And then really tried to evolve my practice and went into private practice, starting to work with other regulated fintechs from robo-advisors, high-frequency trading firms, and fortunate enough to start working with blockchain companies early on in the development of some of these technologies coming into mainstream adoption. I started working with, over 6 years ago, with some of the prominent cryptocurrency exchanges, and grappling with the issues of how do you apply the securities laws to the digital assets that are supported on blockchains. Are they securities? Are they not securities? How do the exchanges determine how they should be regulated? And really evolved as the law evolved in this space, my practice evolved and the market participants evolved over time.
Were you always drawn to kind of regulation and securities regulation specifically, or is that something you just kind of fell into?
No, I always had an interest in financial services in one way or another. I actually have an accounting background, always liked math, which is not a typical background for a lawyer, but I liked the securities industry, the financial statements of when I did audits of public companies, I was drawn to. And so, I don't know, that naturally transcended into some of my experience working with trading platforms and now more emerging financial technology companies.
So as kind of the head of this group, I know part of your responsibilities are to grow the group, to grow the customer base. So what type of clients are coming to you? Are these, like you mentioned, blockchain companies? Are they the exchanges themselves, the companies on the exchanges? Like who comes to you and what type of advice are they seeking typically?
Yeah, so started out my practice when I was in private practice, working with a lot of the early stage emerging technology companies, really seeking regulatory advice primarily. Some were seeking advice on early stage fundraising rounds, either traditional fundraising or token offering fundraising, and also educating some of these clients on the myriad of regulations that may apply to their technology that they may not be well versed in. And it was also an opportunity for me to learn about the various technologies from the developers themselves. Often I was dealing with CEOs, chief technology officers, teaching me about their technology, and then me teaching them about the regulations as they're applying to this technology. So it was very interesting working with some of those early stage companies, which I still do today. But my practice has evolved, and Sidley's practice is also evolved more broadly to, in addition to supporting the emerging technology companies, also supporting our bigger financial institution clients that are adopting and utilizing the technology to reinvent and modify the existing financial infrastructure with integrating blockchain technologies or other emerging technologies. I also work with established companies, public companies, some private companies outside of financial services that are integrating blockchain technologies into their business, from social media to healthcare, supply chain management. All of that is being reconstructed, taking in consideration some of this new technology that's coming into being. And so I work with them on my rate of regulatory issues, transactions, M&A in this space, certainly enforcement actions as the regulatory environment is uncertain in this area. So it's a pretty broad scope of clients that we support now. And another area that's on the rise is just mining, Bitcoin mining infrastructure, mining other cryptocurrencies is also a big area of growth that we're seeing in North America generally and around the world.
That makes a lot of sense. And so do you work often with your colleagues in M&A, which is mergers and acquisitions for those who don't know, or even like you said, enforcement actions with the SEC? Do you work with litigators on those and kind of you're the regulatory legal expert and then they may have kind of more process knowledge?
Yes, so I certainly work on each of those types of matters that you mentioned. Often I'm a regulatory expert on the transactions, so the merger acquisition deals, or we've had a number of clients conduct IPOs or SPAC transactions that relate to blockchain and digital assets. So I can certainly bring the knowledge of the regulatory considerations as it relates to the transaction or the digital assets or blockchain technology that may be involved. But I also bring in my team at Sidley, bring subject matter expertise in educating our deal team, our litigators on blockchain technology and the ins and outs of the business itself beyond whether it's we have to conduct operational business due diligence or drafting the business description and disclosures. We can kind of speak our clients' language given the knowledge base we've gained over the years in working with these types of clients. And then similarly on the regulatory enforcement side and litigation side, we do bring the subject matter expertise and regulatory guidance to our clients in the investigation, but also have a really strong relationship with regulators. And given our relationship and reputation we've built in terms of navigating the regulatory environment and uncertainty, we're able to also proactively advocate on behalf of our clients in those investigations.
Yeah, that makes a lot of sense. So I guess one question I had is, since you have kind of this broad perspective on all these different types of clients, what are the differences you see between them? For example, do the blockchain companies have a lot of in-house expertise? And like you said, you're learning from them, and then maybe you're more of an expert with some of these bigger institutions. Like kind of what does that relationship play out like? Because I imagine there are many instances where the client knows much more about their product or blockchain or maybe, some specific technology, but in other instances, maybe the client is looking to you to educate them a little bit and kind of what that dynamic is like.
Yeah, so definitely, I think both ways. In terms of some clients, I'm educating them about the regulations, and often certain clients come to us early in the process that we work with them in modifying their products and service offerings to align with the existing regulations so that they kind of are, once their product goes to market, it's a compliant path forward. So that I think is more on the emerging company side, especially as some of these tech developers know the technology very well, but not necessarily the regulations and the myriad of regulations, which we can get into that stems beyond just securities laws or SEC's reach. And then the second on the more institutional product side, since we have worked with some of the emerging technology companies, we know how the technology works and what products are already out there and can help educate on the product side, the bigger institutions, as they are, especially on the legal and compliance side, more hesitant to allow their business to proceed with some of these products without fully understanding what the products are, what the risks are. A good example is DeFi. We get a lot of questions of what is DeFi, and I educate a lot of our in-house legal team on the risks related to embarking in DeFi or NFTs, non-fungible tokens, and DeFi being decentralized finance products, and educating those bigger institutions prior to their strategy team or blockchain innovation team launching new products in that area.
So for any listeners who may not know what both those things stand for, would you mind giving them the 30-second version? I'm hoping our listeners know, but you never know.
So decentralized finance is a way for transactions to occur peer-to-peer among two unrelated individuals utilizing blockchain technology without a centralized intermediary to be involved in the transaction. And we see, it's a very broad term that may be implemented in the lending space, in the decentralized exchanges or decentralized insurance space. So there's a lot of different applications, but the concept is peer-to-peers can transact without a centralized intermediary using the technology. Non-fungible tokens are unique technology and code that got created and is available on certain types of blockchains that allow you to create a unique identifier that represents either a physical or intangible asset. So think a unique identifier that represents art held in a vault or in a studio, and you have a digital representation on a blockchain that represents your ownership to that art or your title to that art. And given the unique nature of the technology, cannot be replicated. And so it's non-fungible and is your unique token, as compared to most other tokens. Bitcoin, Ethereum, and others out there are all fungible. So they're interoperable. You have one, I have one Bitcoin, you have another, we can trade them and it's the same asset effectively. And we do, I will add, Zila, we do have blockchain educational series that have launched at Sidley a few years ago that has a number of very interesting webinars that educate clients and general public that are available on some of these concepts.
Yeah, I saw some of those on your website. I'll actually link them in the bio when we post this episode for our listeners, because honestly, a lot of these concepts, it just takes a little digging. Once you kind of dig in, things start to make sense. I always tease everybody that lawyers like to use lots of specialized terms and defined terms and acronyms, and finance does too. So when you mix the two, you end up with full sentences and paragraphs that the layperson may not be able to understand, but that once you dig in, you can definitely wrap your mind around. And a lot of Paul and I, my co-hosts, are always talking about how there are actually so many free resources out there if you're just willing to look and take a look. And so many people like you who are experts in their field are giving away a lot of free knowledge. So people should definitely take advantage. I'm kind of moving into AML because this is a podcast about AML and technology. And I was just wondering, what kind of AML issues have you seen your clients face? Is AML an issue that comes up for you? I know you're more focused on those kind of securities regulation, but AML is obviously a component of that in some sense.
So many of the digital assets that are out there are considered convertible virtual currencies that are regulated by FinCEN for money, effectively money transmission activities or money transmission businesses. So many of the cryptocurrency exchanges or even blockchain companies that support transactions in these assets have to be registered with FinCEN at the federal level and with various state banking agencies as money transmitters. And they are all then subject to Bank Secrecy Act requirements, AML KYC for all users of their platform. So certainly AML plays a big role with respect to digital assets and convertible virtual currencies generally, regardless of whether they are securities or commodities or both. And so that's definitely a big part of Sidley's practice in advising clients on these types of issues. And it's important that this is beyond financial services. I think often the premise of Bank Secrecy Act and AML, there's a presumption that that's financial services activity, but really we see companies in the gaming space, in the social media space, engaged in digital assets, in digital asset convertible virtual currency transactions, and that may be regulated activity that requires AML. So we talk to clients in a lot of different industries about the need to register or possibly rely on an exemption. You may not need to register, maybe exemptions that are applicable to the particular business model that's being proposed.
Yeah, no, that makes a lot of sense. And obviously, for those who don't know, Lily gave a little bit of a warning earlier when she mentioned enforcement actions, but a failure to register, if you have an obligation to do so, can get you in quite a bit of trouble. So understanding, like Lily very eloquently highlighted, when and why you have to be registered and what implications that might have for an AML program you need to set up or other obligations you might have is really critical when you're setting up any type of kind of program or anything else. What type of issues have you seen come up? Are there any kind of pitfalls? I know you mentioned that you work with a lot of emerging companies and that oftentimes they'll bring you in very early. Is that a common pitfall you've seen, that startups don't bring you in early enough, or maybe they bring you in too early, or kind of what are some issues you've seen?
Yeah, so I think traditionally emerging companies don't require a high level of regulatory advice or diligence at the early stage seed round, Series A or B fundraising, and down the road as they become more established companies, they bring in regulatory experts. I think this space, especially blockchain digital assets, is a bit different. We've seen companies get in trouble by not complying with the securities laws early on in the fundraising process, especially as we saw the ICO boom and token sales being conducted without compliance with the securities laws, which the SEC had put out warnings on, and there have been a number of enforcement actions, both settled actions and court actions in this case and scenario. So I do think it's unique in that if companies in the blockchain space, they do bring in regulatory experts early on to determine, are they conducting compliant securities offerings if tokens are involved, and is their platform viable without complying with certain registration requirements. And that may be considering issues such as, does the platform need to register, like I mentioned, the money services business, money transmitter licenses, does the exchange support digital assets that might be securities and have to consider broker-dealer registration or national securities exchange registration or an applicable exemption. If the products, and we are seeing a lot of products develop that are creating derivatives and swaps and futures, do they need to be regulated by the CFTC in the US? And then all of these things that I'm mentioning are all US specific regulators and regulations, but the technology is being implemented globally. And so there are a lot of regulators around the world that are also creating their own regulations that may apply specifically to blockchain technologies or fintechs more broadly as they're trying to capture the global reach of their particular regulations. And so all that said is many of these companies that are growing very quickly at the early stage should just be mindful that an enforcement action down the road is very expensive, costly, and could impair your business going forward, because we've seen a number of companies having to shut down as a result of substantial enforcement actions on a global scale. So the earlier the better, I guess.
Yeah, absolutely. And I would also warn folks that even if, to your point, you haven't gotten to the stage yet where an enforcement action might be appropriate, registering as an MSB takes time. That's not something you can do overnight. Making those filings and filing those applications takes time, which may delay any promises you've made to investors or rollout of a product or a platform or anything else, as you mentioned. So kind of stepping back, our podcast focuses on kind of demystifying some of these spaces and AML for a broader audience. So most of our audience are lawyers and compliance officers, but there are a lot of people who are just interested in the space. It's in the news all the time. So I was just wondering, what do you think are some of the biggest misconceptions that a layperson could have about blockchain and the businesses that your clients are in?
So I think the biggest misconception is really just the focus on the cryptocurrencies themselves, like blockchain is just Bitcoin or that's an investment in crypto assets. I think that there is a portion of investments that are happening in some of these commodities or some that may be securities, but really that's not the value in the technology itself. It's a use case. So payment being one, or investments being one use case that you can use a technology for. And I think over time, we'll see in 5, 10, 15 years, the underpinnings of all of the technology that we use, and this is often referred to as Web 3.0, will be with a blockchain underlier that you don't even know exists. Blockchain is a technology that's revolutionizing the way we communicate, the way we transact and share data. And I think the biggest misconception is some of those benefits and how it's going to change the way that our underpinnings of our technology work. And years from now, we won't even be talking about blockchain. We'll just be using it without knowing it.
Right, exactly. I think that is true. I think many people don't quite understand some of the distinctions. And we've talked about that with some other guests about how, Bitcoin does not equal blockchain, what blockchain actually is. And to your very good point, I think we often think of blockchain in a very specific context when it actually has applicability in all types of different products. It's very interesting. So we spoke with Amanda Wick an episode or two ago about the relationship between government, companies, and law. Amanda is obviously formerly a FinCEN, formerly a prosecutor, now at Chainalysis. You have spent most of your life, from my understanding, in kind of private practice, but and even in-house, but you've also worked a lot with government and obviously worked very deeply in the law and kind of reading regulation and interpreting it. I'm sure helping clients comment on new law that is developing. So how have you felt about the many recent developments in crypto and blockchain? I know you mentioned FinCEN and other regulators. I know that there's been new rules kind of issued and new guidance. Do you feel like that's enough? Do you think that there's space for more?
So there's definitely been a lot of pronouncements, whether proactive, informal guidance from various regulators, and some announcements through enforcement actions, or even we just saw a company, a cryptocurrency exchange sanctioned as well. So there's been a lot of developments, but I do think, and saying this from the perspective of the industry, there could be more and there could be faster guidance. I think the technology is evolving faster than the regulations or even the regulators can keep up. So many feel frustration that the guidance and the way to apply the existing regulations to the technology is not evolving fast enough. And as a result, there's failure to comply or there's regulation by enforcement, many say, and we do see that in some way where the guidance is made through enforcement, which is not ideal, but I do think it's a way to curb some of the growth as the regulators are trying to learn and evolve the guidance with the change in regulation. And in an area, I'll give you a specific example that I've been very focused on is custody and how broker-dealers can support custody of digital assets and digital asset securities. I've been on behalf of the industry very proactive and vocal on the need for more guidance in this area, dating back to 2019, where I published a white paper on frequently asked questions the SEC should be answering on how to apply SEC Rule 15C33 to digital assets within a broker-dealer. And just late last year, December 2020, SEC finally put out a special purpose broker-dealer that allows for certain path forward for broker-dealers to custody digital asset securities, but effectively it's a 5-year safe harbor as the regulators are still trying to think through the broad scope of what might be permissible within a broker-dealer. So it is some guidance. It's not, all encompassing and not, doesn't address every scenario, which we're still working through with clients, but it's an example of regulators taking their time, thinking through how to approach some of these issues and providing guidance.
This is kind of a theme I think a couple of our podcast guests have touched on, which is this idea, and I think you mentioned it even from the outset, this idea that the law hasn't caught up to where we are with technology, with products, with reality, frankly. What has your approach been? How do you kind of approach that, kind of filling that gap for your clients? Because I imagine they come to you and say, we want to come out with this product, and you say, okay, well, here's the existing law, and there's a gap between where the existing law is and this product you want to put out, and it's not 100% clear, whether what you're doing requires regulation, requires registration, for example, or, is whether this is a security. Kind of how do you navigate that gray space and help your clients manage that risk?
There are a few different ways. Certainly one way, as lawyers, we take the existing regulations or legal guidance and precedent and apply it to the fact pattern and use our own judgment in advising clients on a compliant path forward. The second is leveraging our relationships with the regulators and having a dialogue on the gap in regulation or the gray area the clients are operating in and either seeking proactive relief or informal responses and feedback on whether this is the right path forward for the client. I have strong relationship with SEC's FinHub division and have had numerous meetings with them on behalf of clients with innovative products to gauge their reaction to how would the existing regulations apply in the context of those particular products and get either no action relief or informal guidance from them that the client and our advice is on the right path from a compliance perspective going forward. Similarly, on the broker-dealer side, we have strong relationships with the FINRA's Innovation Hub and the key members of their digital asset blockchain team that interact regularly with the SEC. And so we have interactive discussions with them on compliance. And my colleagues on the CFTC and bank regulatory side have similar relationships with other regulators across the Sidley platform to help support our clients in having those discussions. So those are, I think, the two avenues that we'd approach. I would say lastly, just overall industry related, I'm very proactive and involved in various industry groups that are having discussions with the commissioners at the SEC on the need for safe harbors or more guidance, with various congressmen that are proposing bills to modify the existing regulations to apply to this technology. There are various states initiatives that I'm actively involved in talking about whether there should be specific changes to state regulations that may be more pro-blockchain in this area to provide more regulatory clarity where there may not be as much at the federal level yet.
Yeah, no, that makes a lot of sense. And it sounds like relationships are key, which you have in spades. Well, thank you so much for answering all these questions, Lily. Your clients are lucky to have you. And thank you so much for coming on.
Yeah, no, happy to do it. Great speaking with you.
This has been a production of Opinions My Own. I'm Zila Acosta-Grimes, and with Paul Caulfield, we are your hosts, bringing you episodes breaking down the state and future of anti-money laundering, technology, and the law. Thank you to Fordham Law School and our production assistant, Ava Lichter, for their support. If you have suggestions, questions, or would like to be on the podcast, please email us at opinionsmyownpodcast@gmail.com. You can also find us on Twitter at mine_podcast and YouTube at Opinions My Own. Thank you for listening.